First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, great state of Florida, and this honorable court.
Good afternoon. Welcome to the First District Court of Appeal. We have one case on the docket this afternoon. It is number 20-3307, Estate of Ronald McKenzie versus High Rise Crane. Counsel for the appellant, are you ready to proceed?
Yes, sir, and I request 4 minutes for rebuttal.
Okay, I got it. You may proceed.
May it please the court, Jay Levy on behalf of the estate of Ronald McKenzie. This is an appeal from a final order dismissing a petition for benefits, which had been filed by the estate through its personal representative, Ms. McIntosh. It was filed by Attorney Bush. The facts of this case and the procedural history are undisputed, and the question before the court is the effect of those undisputed facts when the law is applied to them. In this particular case, the decedent passed away on August 24th, 2018. His existing claims at that point in time were dismissed because he was deceased. The statute of his industrial accident occurred on January 26th of 2018. On January 24th of 2020, 2 days before the expiration of the statute of limitation, a claim was filed, a petition for benefits was filed, which appears at page 28 of the record. This petition for benefits indicates that the employee was the decedent Ronald McKenzie, but that the claimant was Terry McIntosh as personal representative of the estate of Ronald McKenzie, deceased. Attached to the petition was a...
So, Mr. Levy, who was Mr. Bush representing at that time?
Mr. Bush represented the estate at that time, Your Honor.
Okay, but there was no PR appointed. So how did Mr. Bush do that? How does that happen?
This fact pattern, Judge, appears in at least 5 civil cases under the Wrongful Death Act, all of which are cited in my brief. In each one of those cases, and I would point out particularly 3, the Griffin v. Workman decision from the Supreme Court, the Linder versus Florida East Coast Railway decision from the 3rd District, and the there's one other third, the Talon versus Murphy decision. In each one of those cases with the same fact pattern, they were wrongful death actions. There was no estate filed. The lawsuit was filed designating an individual as PR who had never been appointed, and the appointments took place after the expiration of the statute of limitations. In each one of those cases, it was found that the statute of limitations, that the appointment of the PR related back and therefore validated the lawsuit. In this particular case, although it is in the context of a workers' compensation case, there is no distinction in the context of the fact pattern and in the application of the law.
That's what I wanted to ask you about, counsel. Griffin, at least, I'm not sure about the other cases, but Griffin didn't cite 733-601 because there wasn't a 733-601 back in the 50s. But it does talk about the ancient rule of the powers of the PR relating back to the actions done before the letters of appointment. Does that common law theory apply to a comp case that's a kind of a statutory action in opposition to common law?
Well, I understand that there was no workers' compensation at common law, and this was an administrative procedure designed to expedite benefits to the claimant. But there is no logic, Your Honor, to why that rule would not apply in a workers' compensation setting. Your Honor is correct. 733-601 cited in my brief was not cited in any of these cases. Yet the statute clearly applies and clearly indicates in its plain verbiage that once you get appointed, if you take an action that's designed to benefit the estate beforehand, then that action is ratified when you become the PR. The situation of filing this claim to secure benefits to the estate falls right within the verbiage and the intent of 733-601. It also falls within the verbiage and intent of the Supreme Court in the Griffin case. One could argue that 733-601 is just the codification of the Griffin rule. But to directly answer your question, Judge Bilbrey, I see no reason why there should be a distinction made in a workers' compensation case when the same fact pattern arises. And the only thing that was trying to be done was to protect the benefits that the estate would be entitled to. And these fact patterns are very compelling. I've argued a lot of appeals. It is rare that I get a fact pattern that's relatively close to the one we're dealing with, and that makes it all the more compelling. Now, we were taken to task in this case because of the fraud statement that was attached to the claim. That fraud statement, admittedly, on its face indicates that it was executed 2 years earlier by the decedent. And as I indicated in my brief, that fraud claim was attached to a prior petition for benefits filed by the decedent when he was alive. We're told, and the judge found, although there's no evidence to support it, that this was a scheme designed to prevent insurance fraud on the part of the personal representative. First of all, that argument and that finding are wrong for several reasons, both legally and factually. From a legal standpoint, as I point out, this court's Padilla decision clearly holds that the fraud statement is not part of the claim itself. And Padilla is at 22 Southern 3rd, 124. In Padilla, the claimant had failed to sign the fraud statement. The judge of compensation claims dismissed the case. This court reversed, holding that the failure to sign the fraud statement only results in the suspension of benefits until the fraud statement is signed. In this case, is really no different. There was no proper fraud statement filed with the petition. The result should be to say, but more importantly, this court relied in Padilla on 44192, which indicates what needs to be in the claim. And this court noted that nowhere in the claim did a fraud statement need to be. So therefore, the claim would have been sufficient without a fraud statement. Also, there is nothing in 44092 that requires a claimant to sign the petition for benefits. This becomes important also because somehow the JCC found at page 14 of the record in her final order, she said, Mr. Bush attached the deceased claimant's attestation from 2018, thereby by operation of law making Mr. McKenzie the person making the claim. I know of no authority for that proposition that because the fraud statement was signed by someone else, even though the claim designated a different individual, the person that signed the fraud statement becomes the claimant, particularly in light of this court's decision in Padilla, which does not require the claimant, which indicates what needs to be in the claim, as does 44192, and establishes that the claimant need not sign the form and that the fraud statement need not be in the PFB. So we think that the PFB was sufficient, and the worst thing that could happen in this case to the claimant for not filing a proper fraud statement with her petition for benefits was the suspension of benefits. As this court might have noted from the brief, this was a fully controverted case, so benefits weren't being paid anyhow. We filed a motion, I believe. The claimant, it's significant to note that although the petition for benefits was filed on January 24th of 2020, the estate was open 5 days later and filed on January the 29th. There was always the intent when this petition was filed, when this petition for benefit was filed, to open the estate. It took a while to get the claimant appointed as the PR, and that didn't occur until July 30th. But it is our position, consistent with all the case law, that that relates back to the date of filing of the petition for benefits. And indeed, as Your Honor pointed out, the ancient doctrine set forth in the Griffin case, it goes all the way back to the death of the decedent. It's what the Supreme Court actually held. So it's our position here that the relation back doctrine applies, that the appointment of the claimant as the personal representative related back, and if the claim was inchoate at that time, it became valid and and a proper claim once she was appointed that there is no fraud here on the part of the of either Mr. Bush or his client, because at the very least, it's obvious from a reading of the petition that an improper fraud statement was filed, because it was clear on its face it wasn't signed by the claimant. For all of these reasons, we respectfully request that you reverse the order of the judge of compensation claims, reinstate the case, and also overrule her, reverse her ruling that we were not allowed to file the amended petition, which contained the appropriate fraud statement. I reserve the balance of my time.
Counselor,
Yes, Your Honor.
one quick factual question. The benefits that are being sought, what precisely are they? Are they unpaid medical bills, or if you could just, in a sentence, tell me what they are?
Well,
They don't
there's
have-
a laundry list of benefits that appear in the petition, okay? It says payment for medical care, for past medical care seems to be the primary one of a variety of doctors.
Okay. All right.
Thank you for your time.
Mr. Kagan, you may proceed.
May it please the court, I am H. George Kagan on behalf of Appalese High Rise Crane Inc. and Bridgefield Employers Insurance Company. I request notification when 2 minutes remain, so I might summarize. There are multiple threads to this case, and while Appellant McIntosh devotes most energy on relation back, with the court's indulgence, EC will focus on the thread that can help unravel the whole, namely 441.057 and appellant's construction of same based on Padilla versus Collins. I think we'll be more effective in distinguishing Padilla here and show this is not a mere suspension of benefits case. And to pick up on the questioning of Judge Bilberry, common law theory does not apply. There is plenty of logic supporting its inapplicability here. I will also say parenthetically that there is, where the appellant says there's no evidence to support this and that findings, appellant has not challenged the findings of fact. They are locked in. So, put another way, this might have been an easier case to dispose of had it dealt only with relation back and an absent signature. But there is also the issue here of whether a potentially viable party litigant may knowingly present both false and misleading representations and attestations through counsel on conceded grounds that doing so would be less problematic than asserting the actual facts of the matter.
Well, counsel, if I could ask a question here, I'm sorry to interrupt your flow. What is someone supposed to do in these circumstances where the PR hasn't quite been approved yet, but the statute of limitations ran out? Obviously, you have to file the petition for benefits before the deadline. So what are you supposed to do?
Well, the claimant gives you the appellant gives you the answer within their doctrines. Simply admit the state of affairs as they are. That there is a name for it, the proposed personal representative, and so the doctrines of the common law could be transported more easily into the workers' comp case were that representation been made. Parties have a choice in pursuing a course of conduct. Choices were made in this case, and they have consequences. They chose to put the certification of a dead person on, and as I will unwind my argument, you will see that was part of a plan, as the judge found it, to be a subterfuge.
Well, can I ask you-
Go ahead, sorry.
Go ahead, Judge Maker.
A subterfuge to what end?
Well, a subterfuge to avoid having to say that she is not the representative at this time. They could have said she is not the representative at this time, but they put on the document of 1057 that to avoid. In other words, the whole purpose of this was not a non-signature case. And I'm going to get into the discretion of how the statute is constructed. This is a signature that is a false signature of a dead person, which is a nullity in almost every other application of a law where a pleading is filed, and it is required of a litigant, and the counsel has no client where the client is the dead person. So to answer the question directly, they should have confessed the actual facts of the matter and not constructed a legerdemain that is a shell game to conceal the fact she wasn't even applied yet. That would come 4 days after the filing of the petition, and her appointment came 7 months. And I'll also note that none of these facts were brought to the attention of the judge until the aggressive emotion filed by the employer upon discovery months later.
Well, counsel, when did you first know that this was a petition on behalf of the estate?
The state was taken at face value until discovery in around September of 2020. And very shortly after that discovery, when it was revealed that the estate had only been, the petition appellant had been appointed only a few days before that deposition, employer filed a motion to dismiss, and claimant responded to the motion to dismiss by asking to amend. Only after the aggressive emotion filed by the employer carried below did this request to amend, where there was no petition, personal representative signed, become part of what the judge understood to be the case. So,
Counsel, given the 733-601, after Ms. McIntosh became the actual PR, why does any of this matter?
well, we feel that actions have consequences. When the attorney decides to deliberately game the system, I think the court should take an active interest in this. And to show, this is where I'm going to say Padilla will help shed further light on this, if I may. Remember that the appellant says construes Padilla as saying that 440-105-7 is not a required part of every claim because it's not found under the 440-192 procedure for resolving benefits. We would respond first by arguing a pairing construction should be compulsory via the shall provide admonition of 105, thus requiring the two claims measures be read in paramateria. Notwithstanding for a moment the consequences entailed. We're just saying this should be part of a claim, and Padilla did not hold otherwise literally. In Padilla, the court held the judge, quote, the chief judge cited section 440-105 as authority for requiring a signed fraud statement. Florida statutes does not allow for dismissal when a claimant fails to sign a fraud statement. Instead, it provides suspension of benefits for failure. The precise Padilla holding, which does not literally embrace our circumstances, must be limited to those facts, or this case should constitute an exception, because here we have both a signature, number one, and one that was deliberately affixed as a subterfuge as per the findings of fact by the judge, which have not been challenged.
Well, counsel, if I could interject a question. Typically, if in a situation where a lawyer is representing a client and the lawyer makes some misstep, like let's say it could be a good faith error here, maybe it was a boneheaded error here to put this affidavit in. I don't know. Typically, you don't just dismiss the claim and the client gets shafted, so to speak. You take action against the lawyer. Why doesn't that same principle apply here?
Well, in this case, remember that there is found to be a deliberate course of conduct, which claimant on the carpet through counsel finally conceded was the effect. And he said, I'm not perfect, and words to that effect, but he knowingly filed these documents. And as I said, actions have consequences. And in this case, the statute of limitations was about to run. Now, the claimant portrays the statute as a kind of dark hole, which everybody should sort of roll up their sleeves and help him not fall in. But in fact, the statute of limitations is a socially useful and desirable function, which puts parties on notice with a beacon light that there's an end to this road. And what we have here is an unseemly scrambling right before the statute runs, using multiple misrepresentations of fact and obfuscation, and using a dead man's signature to avoid having to attest that the personal representative was not yet assigned, rather than either leave it blank or say what is true. And this would effectively be allowing a claimant to use the claimant's judgment when they deigned the facts to put in a 105 statement would be inconvenient. So put in a dead man as a proxy. That way it is neither blank nor a false representation.
Well, and the legislature gives the penalty for doing that, which is suspension of benefits until there's a correct statement, right? It doesn't say.
Well, yes, but as I say, Padilla and the statute, well, here I'm going to now get right to the heart of the matter. 105.7 benefit suspension is not directed to inadvertent oversight. a blank page, as it were, but expressly and exclusively to the party who refuses to sign. Now, that is a distinction with a difference. Where a party desiring various benefits simply refuses to sign, durational suspension is highly motivational, unless the claim is later withdrawn for fear of signing. Here, however, based on reasonable inferences drawn within the unchallenged findings of fact, the JCC concluded pasting the dead man's signature onto the attestation clause was a deliberate act aimed at circumventing the legislature's design, which I will now articulate. In this instance, by not refusing to sign, but by setting up a stalking horse in the form of the dead person's signature, this was done in order not to sign. And so the other side of the coin of 440-192 is all specificity. That is to say, putting the employer on notice of exactly the benefits claimed. The 105 side of the coin is installed precisely to prevent sham pleadings, as defined and argued in EC's brief, wherein by appearances, a claim may have all the specificity in the world, but be false. This particular facet of claimant's legerdemain directly thwarts the legislative intent directly through counsel's ingenuity, so as it were. And a sham is a complaint good on its face, but false in fact, and especially where it is known that the party interposing it probably knew it to be false. And the petition of 12420 is found by the judge to have been replete with inherently false contentions known to be such when made. Are these values the court seeks to uphold? Again, actions have consequences. The irony here is surpassed only by the audacity. The legislature's goal is not vouchsafed here by a few months of suspended benefits, where such smokescreen was designed within which to operate for a time. That was the goal all along. Appellant consummated a litigation strategy under cover of the very sort of sham pleading 1057 is enacted solely to thwart.
Well, counsel, isn't it the case that when you saw the filing, or whoever the trial lawyer was, you see that there's an affidavit from a dead person. A person's been dead 2 years. So whatever subterfuges or shenanigans were going on, you knew right away on day one that the affidavit was defective, right?
Well, that was on its face apparent, but the problem was that at that point, the misrepresentation of the person representative status was also there, and it was deemed less a problem at that point. But when it all came down, remember, this is a dynamic process, and you're discovering it in bits and pieces. I put in my brief the extreme recalcitrance of the claimant to make discovery. You found motions for three motions to compel. Twice I listed in the brief. And so finally, when the deposition is held, when the employer trial attorney finds there's not even been a personal representative on the case for 7 months, then it acted. And then claimant moved to advise the judge that the pleadings were actually not correct, that they sought to amend them at that point. And so we think the two pleadings must be read together now. The knowingly false and misleading pleadings were part of a whole as a pattern of manipulation. They didn't need to be made. They could come out and tell the truth, but they didn't do that. They gamed the statutory plan through counsel instead. Once the totality of the circumstances became clear to the JCC, her initial skepticism was assuaged, and your appellees respectfully suggest the results stand, that such facially valid but factually false and deliberately misleading legal pleadings not be condoned, much less rewarded. In conclusion, especially in legal pleadings, appellant through counsel should have set forth the circumstances as they were, described the proposed personal representative as such, and had McIntosh sign the attestation as such. While this is not a statute of limitations case, its imminence was effectively conceded as the impetus for these acts. But this too is an ironic argument which turns the purpose of the statute on its head. The statute is not a sinister black hole, but a good thing, as I said earlier. And it is appropriate public policy house cleaning measure, which puts its end date as in bold relief and encourages measured steps within its time limits, rather than serving as a bad thing the court should accept as good cause for subverting the statutory pleadings during a frenzied race to the courthouse, filing wholly unexplicated delay of over a year. While the estate may be regarded as the party in interest, the estate had counsel, and counsel devised a litigation plan of action, and actions have consequences. Oh, what a tangled web we weave when first we practice to deceive. It is therefore requested the court affirm the order of the JCC, both as to its factual findings regarding motive and the subterfuge, which are unchallenged, and upon the substantive holdings, informed as they are by those factual findings and sound public policy. We thank the court for this opportunity to present argument.
Thank you, Mr. Kagan. Mr. Levy, you're recognized in rebuttal.
Thank you, Your Honor. Judge McClure, I have searched for the appropriate word to describe what went on here, and I want to thank you because bonehead is the word that does come to mind now. I do want to say, I just wish that Mr. Bush knew that he was engaged in this kind of a scheme, because that's as far from what happened here as occurred. There was no intent to mislead. If your honors would look to page 31 of the record, you will see, contrary to what Mr. Kagan just told you, it's not that we cut and pasted his signature onto a fraud statement. Rather, we took a fraud statement from a prior petition for benefits, and I've cited those pages in my brief. The fraud statement on its face clearly indicates it's signed by the decedent, and it clearly indicates it's signed on February 15th, 2018. So there's no intent to mislead, because the problem appears on the face of the pleading. They were so interested in proceeding on this, they would have picked up that right away and said, this is a fraud, this is wrong, it's on its face.
If I could ask quickly, the decedent at the time he signed the affidavit, are they the same benefits that are at issue here in this case?
You know, I wish I could answer that without thumbing through the record. I don't know, but I believe they might have been, they might have added some compensation benefits. I don't know the answer, honestly, but that petition is in the record.
But your point is taken, which is, I didn't fully understand. I thought it was a cut and paste and there was some problem. You're saying there was an actual existing document that was then in whole, as it was currently was prepared and signed, put into the record.
This is the identical fraud statement that was attached to a prior petition for benefits. And I've cited those pages in my brief. The entire thrust of Mr. Kagan's argument, and no one gamed the system here, and I take strong offense to that. And I've known Mr. Kagan a long time. I'm surprised that he would characterize it like that. But this entire argument is debunked by Mr. Kagan's own citation to Linda versus Florida East Coast at 255 Southern 3rd 490. There, the court found in the same situation that the filing of a civil lawsuit by someone who wasn't appointed personal representative was a sham pleading. The 3rd District struck that, reversed that, said no, when the person becomes the PR, that reverts back, breathes life into the lawsuit, it's not a sham pleading. So this entire argument is, well, it may be it may be somewhat ingenious, it's bogus. What happened here is consistent with many, many other cases. I don't read, I believe that Mr. Kagan, if his argument is taken and abided by, then what he's seriously asking this court to do is to sub silencio reverse the Padilla case, which of course a panel of this court cannot do, and which has never been questioned by any post Padilla decision of this court. The petition for benefits is a separate document from the fraud statement. The fraud statement only suspends benefits, as Judge Bilbrew said. Okay. I would be the first to admit that I would rather not be here to argue this appeal, that this whole situation could have been avoided, but it wasn't. And what we did is permissible and consistent with the case law, consistent with 733.601, and this order should be reversed. I thank the court for the time.
Thank you, Mr. Levy. Thank you both for your arguments today. We have no other cases before us, so we are adjourned.
Thank you, Your Honors. Have a great day.
Your Honor.